So today I'm going to start the presentation that I'm going to do. I'm going to talk about the labor law in a nutshell. Basically, it's basically an introduction. So it's going to be a refresher to those who have studied labor law. But the way I'm trying to do it, I'm trying to do it in a more holistic and a way that is going to help us as we represent the people. So, as you guys know, if you talk about labor, you're also talking about employment, which is one and the same thing. If you talk about labor, you also talk about employment. So the question is, what is employment? The question that we have to ask ourselves first before we even start to talk about the labor law. So employment is simple a state where someone, so this someone is called an employee, is engaged in a productive activity, occupation. So it can be full-time or it can also be part-time, and he is working for someone. This someone is called an employer and is doing this activity in exchange of compensation or money. So simple, one person works for the other person, and in return he gets compensation. It can be money or it can be maybe certain benefits depending on the nature of the agreement. So this implies that there is a formal relationship. So this is called an employment relationship. You see. So there's different types of relationship. It can be a partnership, people who are in business together. People can be in a romantic relationship, but this one is a formal relationship, and it's an employment relationship. So it is based on an agreement. So because you agree with that person, so it can be verbal or non-verbal. So this agreement is. Well, I don't encourage actually non-verbal. Verbal, because I'm actually making a mistake. It can be written or verbal. I don't encourage agreements that are not written down, because when something happens, you cannot prove that this is what you guys initially agreed on. See? So especially in construction industry and mining, and also mining, sometimes even farming, the employer will just take people, maybe semi-skilled people, and then put them in the farm to work. You see, and then it doesn't even write for them a contract, and then you just pay them after they finished working. So those people is actually taking advantage of, you see. But if it's someone who knows the law, will ask, can we write it down and make this thing more formal? Sometimes it happens in a companies where the company has hired you before, and then now it's rehiring you again and again. So sometimes they just say, okay, because we already know this person, we're just going to be a verbal agreement. So I think for us, let's encourage the people that we deal with that they must always want their contracts to be written down, because you can prove that you were employed by this person and this person is supposed to pay you. So the legal provisions are primary contractual in this relationship, and also statutory. So when I'm talking about statutory, I'm talking about the law. So both the provisions are in the contract and the provisions are in the law. They are legal, they are binding to that person who's in that relationship. So this legal provision is a contract, it's an employment contract and a labor law. So basically, when we deal with these disputes, we're going to have to look at what the contract says and also what the law says. So I know there's a lot of other things that govern the employment relationship. For example, in my industry, which is the energy industry and chemical industry, there are other things that govern us that are more specific to the industry. But from a general perspective, guys, the first thing you're going to look at is a contract of employment and what the labor law says. And then someone to be an employee needs to be a natural person, and the employer must direct or control his or her means of work. So remember, an employee is different. I think we already touched this a little bit when we're doing the basic conditions of employment, that he must be a natural person, which means he's a human being, and the employer must directly be in control of his means of work. So basically, it's different from a subcontractor. A subcontractor is just coming to provide services, and he's not actually mostly on many things controlled by the employer. He can regulate his hours of work. He can bring his own PPE. He can bring his own equipment to work. That's a subcontractor. But for an employee, you receive all those things: the work schedule, uh, terms and conditions of employment, tools of work. You receive all of them from the employer, so he's got more control on you. So you are basically an employee. So the other thing that I want us to just focus on, because in South Africa we are a constitutional democracy, and if we're going to talk about the labor law or employment law, we need to understand that the constitution is the supreme law of the country, or is the most basic law of the country. So in our constitution, if you deal with chapter 1, it talks about fundamental rights of all the citizens. Chapter 22, it deals with the freedom of trade, occupation, and profession. And then chapter 23, it deals with basic employment rights. This includes the right to have fair labor practices. So we talk about fair labor practices, we maybe going to deal more when you do Labor Relations Act. You talk about promotion, benefits, that you need to be treated fair when it comes to benefits, training, promotion, allowances. So those are fair labor practices. And it also talks about us, that someone has a right to join.
Hi, Masande.
Hi, Susie.
Sorry. I just wanted to ask a question. Good evening, everyone. Sorry I joined late. Where you mentioned a subcontractor, right? So sometimes a subcontractor comes with their own employees. Do we still not regard them as our employees?
They are employed to a subcontractor.
To the subcontractor. Okay. Yes. And then temporary employment services, would those be employees to the TS or to the employer or the client?
Okay, so the temporal, or I said, if you started when you started that, it can be full time or part time. So even temporary employee services are still our employees if we have got direct control over their means of work. So those are still. So it becomes complex now when a third party is involved to bring his own people. Are we maybe we can talk about this? Are we going to call those people our own employees, or are they just the employee of a subcontractor? But at the end of the day, they are employees.
Okay. Yeah. Okay. Thank you.
So what is your can you share your can you share your experience on this?
The subcontractor, 100%, you're correct. They are regarded employees, but the employees of the subcontractor. And obviously, whatever rules that the client might have, like let's say, for example, it's a construction site, and you've got someone that is subcontracting whatever the big contract is. So let's say we're building a mall, and then you subcontract someone that's going to do the ceiling only. Those employees are not ours. They're the subcontractor's employees, 100%. And then for temporary employment services, so let's say, for example, I need people only for December. I do not pay these people. Everything else is handled by the temporary employment services. So be it PPE, be it salaries, be it public holidays and everything else, what they do at the end of the month, they just invoice. So let's say they say our employees are going to get paid every week, for example. So we're going to invoice on a Tuesday to pay them on the Friday. We're going to invoice you as the employer, well, not the employer, but the client, right? Then everything else in terms of their, if I can say, their duties and whatnot, it is going to be given by the client, whoever site they are on. However, then there's that clause, 3 months. Ne?
Yeah.
If after 3 months they are still fixed term and they obviously belong, because the contract they would have is the contract of the temporary employment service, right? But after 3 months, Section 198 says they are deemed to be the employees of the client. So if I'm building a mall and I need general workers, and then I hire Sizabantu employment services to bring employees for 2 months, they are 100% the employees of Sizabantu. But the moment we go over the 6 months, if we don't have a justifiable clause to say it's project 2025 Tembisa Mall, then they could be deemed to be my employees.
Yes. You're right. You're right. Because at the end of the day, you're the one who's providing, they are working for you at the end of the day. So after some time, the status change to they become your employees. All right, thanks for that.
Yes,
Yeah.
because, no problem. Because before companies, I think in government, they still do it even now. They enjoy putting people on like 5-year fixed term contracts, you see. And then what happens is you're losing all the permanent benefits. So they'll say, you're not going to get medical aid because you're a fixed term employee. You're not going to get Provident Fund because you're a fixed term employee. It's only EUIF and SLR. So then that's when that came into effect. I think the unions back then, when Section 198 came into effect, that's what they were fighting against, that you are a worker of, for example, the Tembisa Mall, and then I'm coming in through an agency. So if I'm coming through an agency, you and I are both general workers, but I don't have the benefits you have. And then they say, no, it's because now you are temporary, you see.
Yeah.
So, yeah. I think that is quite something important to highlight, that someone can come and say, I've been here for 2 months and I'm their employee. And by the time we refer to the CCMA, we have to go back because it's a wrongful citation.
Yes.
So we cited the incorrect employer. Yeah.
Yeah, thanks, Wendy, for that. So, guys, I was still dealing with the Constitution and the fundamental rights. So I already said that to join a trade union is a fundamental right of a person. So the person is a fundamental right to join the trade union of his or her choice, and you have a right to actually to strike. You have a right to protest. And then Section 34 deals with the access to administration of justice. And actually, I like this extract from the Constitution. Everyone has a right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court where appropriate, another independent or impartial tribunal or forum. So the independent and impartial tribunal or forum, it includes the CCMA, includes the bargaining council. So what this means is that it's a fundamental right of a person to present his dispute to the CCMA or to a bargaining council. So all these things are actually embedded in our Constitution. So, and then Section 36, it deals with these rights. It says these rights may be limited in terms of the law of general public application to the extent that the limitation is reasonable and justifiable. So it can be limited, your rights. For example, the Labor Relations Act, it says you've your right to dismissal, maybe to bring your application or to refer a matter for a dismissal. It's only you must refer it within 30 days. So you see you have a right, but that right is also limited. You see, because it is justifiable, because we also want a speedy resolution of disputes. So since now we dealt with the Constitution, I want us now to turn to how we move from the Constitution to the labor laws that we are going to be dealing with. So before we do that, we need to understand what is called an Act of Parliament, which is mostly Section 55 of the Constitution. There's something that we call a bill. A bill is a draft law that is presented before. It is a bill before it becomes a law. It is presented and it must be passed in both houses of parliament. So in South Africa, we've got the National Assembly and I think National Council of Provinces, NCOP. So once it's passed in both houses of these parliaments, then that draft law is sent to the president to accept it. Once the president has signed the bill, that is passed by both houses, so it becomes an act of parliament. So an act of parliament, it becomes the law of the land. So the act of parliament are also called the statutes or legislation. So that's why if you talk about labor law, of course, say Labor Relations Act 66 of year so and so, you see. So it's because it is an act of parliament. It was first passed in parliament, and then it was signed into law by the president, and then it became a law. So when you talk about an act of parliament, you're also talking about a piece of legislation, like the Basic Conditions of Employment Act or a statute. So it's very important to take note of these words, that you're talking about one and the same thing, an act of parliament, statutes, or a legislation. So in employment, we've got our employment statutes in South Africa. That is the labor law. It includes the Basic Conditions of Employment Act, includes the Labor Relations Act 66 of 1995, Occupational Health and Safety Act 75 of 1997, Skills Development Act 97 of 1998, and we also have got recently in 2008 the National Minimum Wage Act. But the other thing that I forgot here to include also, there's also have got Employment Equity Act. I think I forgot to put it here. So now, once in these acts or in these statutes that we have, I want us now to focus how is the CCMA came into existence, and the labor courts. So now we moved from the parliament and then to the acts of parliament. So now they are passed into law. So now they are becoming a law. So whenever there's a law or a piece of legislation or a statute, it always comes with what we call a treacher of statute. A treacher of statute is something that is a specialist institution that is created and is formed by the statutes. So it derives its power and jurisdiction from the provision of the statutes. For example, if you're talking about the Labor Relations Act, the Labor Relations Act is a statute. It's an act of parliament. It's a law. So the Labor Relations Act, it forms the establishment of a CCMA. You see, so CCMA is actually a treacher of statute. So so maybe before I explain about CCMA, the treacher of a statute, it derives, because it is formed by the constitution, it is formed by the legislation or by the statute. It's gonna derive its power from there. You see, so this means that the treacher of statute cannot act beyond the scope or in a manner that is not explicitly authorized by the law. So, for example, it says we must refer the disputes, unfair labor practices within 90 days. So CMA cannot act outside that. That's why if you're going to do something outside those requirements, you must submit a condonation application to explain the reason. So you can lose basically a case by referring a dispute outside the parameters of a statute. So the CMA, even if the commissioner can be lenient to you, but they will always make their decision based on what the statute says, based on what the Labor Relations Act says. So in our employment jurisdiction, the statutes that we have is the CCMA, the Bargaining Council, the Labor Court, and the Labor Appeals Court. The core functions of these institutions are labor dispute resolution. They dispute through conciliation, which means that there's a third party who's neutral, trying to help the parties in a dispute to reach an agreement, and through arbitration. Arbitration is when a commissioner is going to every party is going to represent its case, and a commissioner will make a final ruling, and it's going to be binding. So and then the functions of a labor court is reviewing an adjudication. So they will review the decision of the bargaining council and the CCMA, and then they will adjudicate or adjudicate it. I know this one is mouthful. Maybe we can just slow down and then just ask you guys do you guys understand what I mean specifically when I'm talking about what I say, this part, when I called it the treasures of a statute, which means the institutions that are formed by the institution. I just want to hear, guys, your understanding on that. When you can also comment as well, just to enhance what I'm already talking about. Maybe you can explain in your own understanding as well.
Okay, I thought I was going to let the rest of the team first give in what they understand. And then if there's anything to add, then I will, because I think you've explained it 100%. I think, however, I would have a question. So if you're saying it is a creature of statute, if we say, let's take the CCMA, yeah? The CCMA is a creature of statute, right? And you're saying it is formed by a specific statute. If we were to look at a specific one for the CCMA, which one would it be? Would it be the basic conditions and the labor relations?
Okay, so each and every so they're basically formed by the Labor Relations Act, but they're also given powers by other statutes, like your but your main statutes will be Labor Relations Act that tells the governing the processes. Other statutes will normally refer the disputes, but will not really talk about the processes more of how they should be.
Okay. Okay. So if I'm then to explain to the rest of the team everything that Masande said, it's basically since we are going through, for example, the basic conditions, right? If there's certain monies that are owed to me, I worked overtime, I wasn't paid, I was not paid my full salary, then the CCMA, when we refer section 73, which is based on legislation or statute, which is the basic conditions, right? Then they are then given powers to decide whether or not you owe this person money or not, depending on who has obviously the evidence to prove, to say, yes, by this date, this money needs to be paid over because as the commissioner found that you do owe this employee money, right? Then we look at another statute, which is the Labor Relations Act. So the Labor Relations Act, going to Schedule 8. Schedule 8 tells us about is the code of good practice. It tells us about dismissals, right? So when I get to the CCMA, I can't say, I'm not sure why I'm here, but I referred a matter, For you to even refer a matter, you can say, okay, I was dismissed. I think now the CCMA has something like dismissal for unknown reasons. So then you can prove I was given a letter, this is what happened. Then the CCMA has now powers to deal with that dismissal based on the Labor Relations Act, which is Schedule 8. So meaning if I just go to the CCMA, I'm not owed money, I am not dismissed, I am not sort of not given a promotion when I was supposed to, I was demoted incorrectly. So if I just go to the CCMA and I say, I don't know why I'm here, then the CCMA doesn't have powers. So everything that we refer to the CCMA would have to be through certain statutes, certain legislations, and so forth. So even when you go to the CCMA, you cannot refer a case to the CCMA using case law. You can use case law to substantiate your case, but to open up the case at the CCMA, at the bargaining council, it has to be through a piece of legislation.
Yeah, and then another way, just maybe to explain it, for example, the rental tribunal, because I was busy dealing with the rental tribunal, what you call the rental tribunal, yes. So I can't refer matters of labor to the rental tribunal because it is a creature of rental tribunal, of rental Housing Act. So basically, with this one, it only deals with the matters that are assigned to it by that specific statutes. So SSMA is given powers by those statutes, by the labor law statutes. So it will only deal with those matters that it has been given power. It won't take other matters that fall outside the scope of their jurisdiction, because they are formed specifically to deal with labor matters. And they are okay. Yeah, thank you, Wendy. Okay, so I'm gonna move on to the next one. So in the, I'm not gonna go, but I just want to show you that the labor law is quite broad, because you also got what we call the sector education and training authorities, are called SETAs, which basically their functions are skills, occupational and career development through funding and training. So they promote the skills development in a certain industry. So for example, the industry that I'm in, we've got a SETA for the chemical industry. And sometimes they come and do presentation, and sometimes they do offer learnerships, and sometimes even engage with the employers on the types of programs to upscale us in that in the chemical energy sector. So those are formed by to deal specifically with skills development by the skills by the nationals, what do you call this law, Skills Development Act. Yeah. There's also a compensation commission for occupational diseases and injuries, so it falls under compensation of occupational injuries and disease act. So I didn't want to spend much time on them, because these are not matters that will deal with them on a regular basis, but there will be times when we have to talk about skills development in the workplace, and maybe there will be members that are injured, and they have to advise them where they must go to submit their claims. All right, so there's also, in terms of labor law, there's also a government executive function. Yeah? So remember, now we have dealt with the CCMAs and also which are the treasures of statutes, which are more quasi-judicially and also judicial functions. But now there's also a legislative part of government which is dealt by the maybe by the Department of Labor, Employment and Labor. So there you've got staff members for administration duties and daily operations of the department. You've got also labor inspectors. That's where you're going to go for complaints. You can even submit complaints online anonymously if you feel like certain parts or certain provision of the Basic Conditions of Employment Act, the employer is actually undermining them or violating them. So basically, the Department of Labor will, especially the labor inspectors, will deal with the basic conditions of employment. Maybe the staff is not given PPE, the staff is mistreated. So the labor inspector can go and inspect and make a finding about the workplace. So the cabinet minister that is responsible for that is the Minister of Employment and Labor. And the core functions is the implementation of employment regulations and code of good practice, and these are implemented to supplement the statutes. So the labor minister has got a huge function in terms of labor law, because they can even vary the conditions of employment. I remember in my workplace, when you've got emergencies and maintenance emergencies, we apply to the Department of Labor. The employer normally engage us as employees and then say, okay, you guys, we need to work 24/7 to make sure that we finish this maintenance so that we can be able to, the company can continue running. So can you give us a permission, and then so that we can apply to the Department of Labor? So then the minister can approve that the working conditions to be varied outside what is stipulated by the Basic Conditions of Employment Act. So it also, even when there are changes in regulations, new technology coming in, code of good practices. So the minister is very much involved in labor law, the minister, and he also oversees the normal daily operations. So I think it's gonna be good for us maybe to just maybe as homework, maybe to give each other, maybe say this week, maybe can we study about this department, and then the following department we start about, maybe the following week we started about another department, or maybe another institution. But yeah, the Department of Labor is very much involved in employment. We need to study these processes, guys. We need to know its website. We need to know its processes. We need to know what they are doing. We need to know their offices. We need to know basically anything about, even when it comes to UIF, you're going to have to deal with the Department of Labor to submit your UIF claims. So there's a lot that we need to know about the Department of Labor. There's something that I also forgot to mention about when it comes to the government executive, their function in terms of labor law. There's also a Parliament Standing Committee on Employment and Labor, so which oversees the Department of Labor. Which remember the Parliament keeps the executive into account. So the executive, which is the minister, they account to Parliament. So in Parliament, there's this Parliament Standing Committees on Employment and Labor. I was actually studying about it, I think yesterday. So you can also lay complaints if you are not satisfied with some of the things about the Department of Labor. They also engage with NGOs on different labor issues. So yeah, I haven't studied much about it, so I'm trying also to study and understand the roles and what are the issues that we can refer to the Parliament Standing Committee on Employment and Labor. All right, so maybe we can move on to the last part of my presentation, which is the case laws. So for us to understand labor law, we also need to understand what is called a case law. A case law is a law that is based on legal precedents. That is the judicial decision from previous cases. So remember, that's what Wendy mentioned earlier, that the case law sometimes explains further the legislation. So we talk about the legislation or the statutes. Sometimes certain provisions are not clear. So it will be the case law that will tell us. For example, the case law, maybe when it deals maybe with retrenchment, and maybe the legislation is not clear on certain things, but the case law that deals with retrenchment will give you more details on that. So you're looking at the law, the legislation, and you're also looking on the case law when you are going to argue your case or any dispute. So there are four things that you need to remember the case law. So the decision of the highest court is binding to a lower court. For example, the Labour Appeals Court decisions are binding to the Labour Court. Also, the decision of the Labour Court are binding to the CMA, because CMA is lower than the Labour Court. So also the decisions that have been accepted of the same court are binding to present decisions of the same court. So decisions of the Labour Court are binding to the Labour Court. However, in exceptional circumstances and under justified circumstances, a court may depart from its earlier decision. For example, if the Labour Court decides that, hey, we've been deciding this matter this way, but because now things have changed, they have a right to decide it in a different way, because it's the same court. So also another thing that we need to understand is also amendments in legislation. When the law changes, so it may lead to changes in the case law, because it means that the case now have to be interpreted differently by the judges. For example, now I know there's an employment equity bill. There's an employment equity bill. So if there's an amendment in the Employment Equity Act, so the case laws that we have been looking previously, it might the judges develop the case law again to ensure that it corresponds with the recent changes. And then the other thing, the most recent judgments are influential and authoritative on present decisions. So whenever you're looking at the case law, also try to look at cases that are more recently. I know, especially now in the constitutional democracy, I don't even look at decisions that happened during the time of apartheid because they have changed a lot, especially when it comes to employment law. But for me, I normally, when I look, I also try to get the most recent decisions. The decision that happened this year, the decision that happened last year, because the law sometimes changes. So when you talk about precedents, you need to make sure that you are always, what can I say? You are always you always make sure that you get a relevant case law, and you always move with times as well. So I'm gonna look at some examples of the case law because I just want us guys to understand how it influences the way we're gonna approach the matters and the disputes that we're gonna have. For example, if let's say I'm dealing with a case of representation by a trade union, so I can quote this law. I can quote this case law and say in the National Union of Metal Workers and of South Africa and Lufin Istebe and others, the Constitutional Court confirmed that the trade union is bound by the limitations it had placed on itself in its own constitution and cannot represent employees outside the scope stipulated by its own constitution. Unions must first amend its own constitution to admit and represent employees outside which they are previously excluded. So if you think about our constitution as Atu, we need to make our constitution more open so that we don't lose on technicalities, because the employer can actually challenge us and say, you can't represent people in the fishing industry because your constitution does not deal with members in the fishing industry. So which means that before we present those people, we need to quickly go to our constitution and amend it to make sure that it includes those employees, because we can lose on technicalities. So basically, NOMSA wanted to present people outside that were not recognized by their constitution. So, but they ended up losing the case on technicalities because they didn't amend their constitution. So there's also, let's say maybe there's an application about condonation application. So you can also look at this case law as well. I'm just going to go to the case law. It says that this is the decision of the Labour Court. It held that the overwhelming precedents in this court, the Supreme Court of Appeal and the Constitutional Court, for the proposition that where there is a flagrant or gross failure to comply with the rules of court condemnation. Okay, I think I wrote it wrong. Say a gross failure to comply with the rules of court condemnation may be refused without considering the prospect of success. So think about good time and case management. So that's why I always focus. I say when I'm given a case, I always give myself a deadline, because it says I've lost cases previously because of submitting late. So if there's no explanation, or you have failed so much, let's say you're supposed to submit a case within 90 days and you submit it maybe after a year, the court might just disregard, even though your case is strong, you've got prospect of success. You can say, the failure is so gross and is so big that we're not going to even look at the application. So remember we said that the courts they are a creature of statutes. They respect the time limits that are set by the statutes. So so the condemnation application, if you have failed so much in bringing your case on time, it can be disregarded. So there's also another one when you deal about disciplinary procedure. You can also look at this case law. Yeah. Because in this case law, it was held here in the court. It must be borne in mind that the disciplinary code is a mere guideline whose application depends on the circumstances of the case. You see? So remember now, the employer can use can change the disciplinary code, and you're not going to win by saying that they just change. You need to prove that the disciplinary code was not fair. So the only thing that is important in the disciplinary process is that there must be equality and fairness. So it is just a mere guideline. The employer can change it tomorrow and adopt another type of disciplinary code. But what is important that there must be fairness. So you can't claim that you've been, because it's a different code, without justifying the fairness of it, if it was unfair off. So that's what is important, equality and fairness when you're dealing with the disciplinary process. So lastly, the case law, I just want us to look at it. If you may be talking about what is the burden of proof when you're dealing with a misconduct in the workplace. So in this case, Banjwa versus Shoprite Checkers and others, this is a labor appeal court decision. It was held as follows. That the employer bears the onus to prove on the balance of probabilities that the misconduct was indeed committed by the employee concerned. There need to be tangible and admissible evidence to sustain a conviction for misconduct. So basically now it means that a mere suspicion is not enough, a mere suspicion that a person has committed a misconduct. The employer carries the burden of proof. He must prove, he's the one who must prove first that, okay, this guy has committed a misconduct. So a suspicion, just to suspect that this person is wrong, is not enough. There must be a tangible evidence. So these are the case laws that you can deal. There's a lot of them, guys, case laws that you can go through. And in each and every matter that you are dealing with, you need to understand what is the legislation saying about it, what is the case law, and what are the facts. So remember, the case is decided based on facts of the case and also on the law. Sometimes you might have the right facts, but the law might not be on your side. Sometimes you might have less evidence, but because you know the law and you apply the right law, you can win the case. So guys, thank you so much for this session. We're done for today. Before we finish, we wrap up on other things. Any question? Any comment?
There's just a comment I'd like to make, Ne? Based on your last slide, the onus of proof, right? For labor matters, it is always on a balance of probabilities. So meaning, I always used to envision I think it's the lady of equality, the one that has a blindfold and she's got scales. She's got scales in her hand. Ne? So whoever has the most evidence, because remember at that point, a chairperson would look at the fact that I was not there, but whoever can produce the more evidence and the scale tips on their side is most likely the more probable side, right? With criminal matters, it is beyond a reasonable doubt. So there should not be one doubt that you did not do it. But that is very important because for certain issues that we dispute or we fight against, we always mention that on a balance of probability, we find it, for example, highly unlikely that the employee would have done it because, firstly, they were not there on that day. Secondly, the video footage is it's short. You can't see who's actually there and so forth. So that's the only thing that I just wanted to highlight from everything else that you've said, Masande, that balance of probabilities all the time.
So if you do a disciplinary disciplinary hearing, ne? So the employer, when you say he's got the burden of proof, he must prove that you have committed a misconduct. Once he has laid his version, you need to give your own version as well, and the person who's decided will look at both versions on a balance of probability and look at which version is more probable given the circumstances and the facts of that matter. So he looks at both versions, but it is the employer who first must establish it, ne, that there is a misconduct. And then you bring your own version, and then he looks at both versions and say, okay, which one is more probable? So that's what balance of probability is all about. All right, guys, any other comment?